a foreign source. So this is the amendment which has been brought, and we have mentioned this, my lord, at page 10 of our written
That has, strictly speaking, no relevance to the challenge on the electoral bond scheme.
True. But I am only saying that...
Which is perhaps why the solicitor mentioned that.
Yes. But
has been detagged. That issue was detagged.
What is the segregation of 3 cases? 31st of January 23 order. Your lordships, my lord, were pleased to segregate.
In this, my lord, the original amendment of brought in by the Finance Bill of 2016 to the FCRA has been challenged.
Right. What is the next challenge in your petition? We'll just at least have a broad purview and then we can go on to the...
So the challenges are all in this chart, if your lordship just sees.
Page 10.
Page 7, volume 1, page 7, in our written submissions. Yes. So first is the amendment made to the Representation of People Act. Earlier, my lord, the Act said 29C. On the left side is the original and the right side is the amendment. Amended. Earlier, my lord, the Act said, RP Act said, the treasurer of a political party or any other person authorized by the political party in this behalf shall in each financial year prepare a report in respect of the following, namely, A, the contributions in excess of 20,000 rupees received by such political party from any person in that financial year. B, the contribution in excess of 20,000 rupees received by such political party from companies other than government companies in that financial year.
You are at page 10.
Pardon, Lord?
You are at page 10.
Page 10. At the bottom, 7, sorry.
7.
I'm sorry, page 7. Page 10 was that FCRA I had taken about. Page 7.
Yes, please.
So, left side is the original provision. And then, my lord, 4 said, where the treasurer on the left side, original, where the treasurer of any political party or any other person authorized by the political party in this behalf fails to submit a report under subsection 3, then notwithstanding anything contained in the Income Tax Act, such political party shall not be entitled to any tax relief under that act. Because contributions to political parties are exempted at both ends. That is, it's exempted at the end of the party which receives the donations from tax, and it is also exempted at the end of the donor. That is, the donor can claim an exemption by way of the donations that they have given to a political party. Now, your lordship will see the amendment. I have highlighted the relevant part. Provided on the right side, provided that nothing in this subsection shall apply to contributions received by way of electoral bonds. So therefore, the reporting requirement as to who has donated to you in excess of 20,000, which was earlier there, has been removed for donations received through electoral bonds. This is the first amendment to the Representation of People Act. Then they amended simultaneously the Companies Act. All these amendments were brought in through the Finance Bill of 2017. Finance Act of 2017. Now the Companies Act 182 originally prescribed, notwithstanding anything contained in any other provision, a company other than a government company and a company which has been in existence for less than 3 financial years may contribute any amount directly or indirectly to any political party, provided that the amount referred to in subsection 1, as the case may be, the aggregate of the amounts that may be so contributed by the company in any financial year shall not exceed, this is important, shall not exceed.
So Supreme Court hearing a batch of petitions challenging the electoral bond scheme. In fact, a case centering on a series of pleas contesting the amendments introduced in the Finance Act of 2017, which facilitated the implementation of anonymous electoral bond scheme. Let's go straight across to Harish on this. Harish, Petitioners Counsel Prashant Bhushan there arguing. Take us through the proceedings in the court at this point as far as electoral bond hearing is concerned. Yesterday, of course, the centre had filed affidavit saying that citizens don't have the right to know source of electoral bonds.
Yes, You're very right. In fact, the petitioner, Prashant Bhushan, led Association of Democratic Reforms, CPM, and condemns that the bonds had legitimized corruption at a huge scale and maintained complete non-transparency in political funding. And petitions claim the electoral bonds have opened floodgates to unlimited corporate donations to political parties and anonymous financing by Indian as well as foreign companies, having serious repercussions on the Indian democracy. As already said, Attorney General R. Venkatraman had submitted his views already, stating that the citizens do not have a fundamental right to know the source of these funds, and cautioned the court against entering the policy domain for regulating the electoral bonds, saying that these are policy decisions and Supreme Court should not intervene. And now the matter is before Supreme Court. The Attorney General had argued that scheme does not violate any existing rights and ensures clean money is contributed. He also emphasized that the importance of a parliamentary debate on such matters. Centre has already said that now system is very transparent. Bonds bought in transparency and accountability. So now the hearing is on. We'll debate and watch what will the observation of the Supreme Court.
All right, so the hearing is on. We'll wait and watch out for what will be the observations made by the Apex Court. Prashant Bhushan, Petitioners Council, currently making certain submissions. Thank you, Harish, for the details.